Good evening, students. Please confirm about the voice and the video. Very good evening, Shivangi. No voice. Come on. Students, voice check. 1, 2, 3. Voice check. 1, 2, 3. Okay, it's working from here. Please confirm about the voice. Voice check. 1, 2, 3. Okay, why? Okay, GK and law has confirmed that voice be clear है अभी. ठीक है. Okay, I guess we are ready to start the class now. Okay, Ji. On that note, let's begin with this class. So first of all, I welcome each one of you to my class on IPC. Let's start with my brief introduction. Those of you who don't know my name, it's Sandeep Khatri, and these are my areas of specialization: the constitutional law, criminal law, commercial law, family law, jurisprudence, and law of torts. This is the link of my profile of Unacademy. So make sure you follow that to get all the updates about my special classes and my plus courses. This is the link of my Telegram channel where you can connect with me. And at last, this is my code Khatri10, which you can use to get free access of all the special classes available on Unacademy app. Students, I request everyone, please be attentive, and this is going to be interactive session. So the topic which we were doing from the last class was section 299 and section 300. We were just discussing the landmark judgments in relation to these sections. So we are already done with Moti Singh versus State of UP 1964 Supreme Court. If you have any questions till now, you may ask in your comments and I'll answer accordingly. If not, then quickly give me a thumbs up. I'll move forward. Yes, please. Waiting for your comments. Very good evening, everyone. Those of you who have just joined. Saroj Kumar, very good evening. Okay, Shivangi and Shivgauri, thank you very much for the thumbs ups. On that note, let's begin with the next case law. So students, here I am going to tell you the facts of the case. Okay, so how we are going to cover this class for someone who is attending this class for the very first time. So students, I'm just going to tell you the facts of the case. And now after that, I'll raise the issue and you are going to tell me the answer with the reasons. Okay, so here are the facts of a case. So there is a Mr. X and he basically teased a woman. Done? Which means that basically when the woman was in the market, that person, Mr. X, has passed some remarks. Okay. Now this woman came into her house and told all the story to her brother. And now her brother, Mr. B, and the friend of the brother, so I'm naming him F. So now B and F went to X house. Done? Moving forward. Now, Mr. B has started using some abusive languages. Done? When he reached X house and Mr. B used some abusive language and even done assault as well on Mr. X, that he's going to kill Mr. X. And now Mr. X is running towards the field. Okay. Now, as per to the facts, there was, while X was running, there was somewhere 15 to 20 feet of gap between X and B and F. Okay. And now Mr. X jumped into the well. To just save himself, he jumped into the well. Now Mr. X died because of this. Now the question here is, now these were the facts of the case. I'll repeat once again. Now the issue that has been raised here is whether B caused X death. That is something which we need to decide. I'm repeating myself. So there is one person, Mr. X, who passed some comments to a woman, and that woman comes to her house and told all the story to her brother. And after that, the brother and his friend went to X's house, and then X runs towards the field, and there was gap of 15 to 20 feet, gap between while they were running, and Mr. X jumped into the well, and because of that, X died. Now in these circumstances, because death has taken place, now you need to decide whether B caused X death, yes or no. And better if you can write the reasons as well, whatever your answer is. Yes, please. Very good evening, everyone. Those of you who have just joined, Kumar, Praful, and everyone. Yes, students, waiting for your answer now. Okay, Shivangi, first one to answer no. Oh, sorry, Shivgauri, first one to answer no. Shivangi, again no. What about others? Yes, please. Students, I have already told you the class is going to be interactive. So it means you have to participate. Whatever you feel like, you may write. Whether B caused X death, yes or no. Okay, Shivgauri and Shivangi, please do write your reasons as well. Please do write your reasons as well. Kumar Praful, no. Answer without a reason is no answer. I hope everyone do understand the concept of speaking order, or even if a judge is passing a judgment, there are always reasons. And this is the reason that in mains you have to write the reasons of your answer as well. Okay. Okay. Now let me answer this. Okay. Shivgauri, I have read your answer. Kumar Praful, I have read your answer and the reason as well. And Shivangi, your answer is no, but you are saying it is a case of culpable homicide. Okay, now let me conclude. Now please listen carefully. Okay. The answer to this question is whether B caused X death, yes or no. The answer is no. Now coming to the reasons. Why no? Because X jumped into the well by himself. There was no evidence to support this statement that if Mr. X has not jumped into the well, then Mr. B and Mr. F may probably kill Mr. X, which means there was no gun or any kind of sharp weapon in the hands of B and F. And this is why we are concluding, as per to the facts of this case, that Mr. B has not caused the death. Mr. B has not caused the death of X. I hope it's clear now. If it is clear, quickly give me a thumbs up. I have more questions attached to this one. Okay, Garima Nair has raised a very relevant point. He was not in a situation that he was left with no other option. That's completely fine. You may write this reason as well. There are other reasons, he may run towards some any other direction as well. Okay, so that can also be a very good reason. Okay, now I'm coming to question number 2. Okay, my question number 2 is, students, in this same case, if the answer is no, if the answer of the previous question is no, now you tell me it's culpable homicide or it's murder. This is my second question towards you. Yes, please do answer, and please do answer with your reasoning that, okay, if I'm saying culpable homicide, this is my reasoning. If I'm saying it's a case of murder, this is my reasoning. Okay, so I can answer more appropriately to you. Shivangi, culpable homicide. Kumar Praful, you have written S, sir. So I'm not getting what actually you want to say. Yes, what about others? Okay, Shivangi. I've got your reason as well. What about others? Be quick while writing answers. It is suicide by X. No culpable homicide, no murder. Shivagori. Okay. What about others? And now I have a question number 3 as well. Answer to second question, students. It is neither culpable homicide and nor murder. Okay. And by the way, Shiv Gauri, this is not suicide, right? Okay. He don't want to kill himself. So it's not suicide, right? Now my last question, and after that I'll just sum up the whole concept. And the last question I'm raising here is, students, if a person is not causing death of another person, can this person be liable for culpable homicide or murder? I'm repeating myself. My question is, if a person is not causing the death of another person, now can this person be liable for culpable homicide or murder? Answer to this question. Yes, please. Okay, now I have question number 4 as well in my mind. And if you can, just catch this, all these questions are basically from your comments only. All these questions are basically from your comments only. If you can catch that. Yes, please. Be quick. Kumar Praful, first one to answer, no. What about others? No, because that person has no intention nor act to cause culpable homicide or murder. Okay, Gayatri is saying culpable homicide. Okay. No. Shivangi has now changed her answer. I can see that. Chalo, now let me answer that. If a person is not causing death of another person, can this person be liable for culpable homicide or murder? The answer is absolutely not. Now coming to the reasons why no, sir. Because when you will go with the wordings of section 299, you may divide the complete section 299. You may, done? Mark my words, you may divide section 299 into 3 parts, and in all that 3 parts, there is one concept which is going to be very, very common, and that concept is causing death. Which means if a person is not causing death of another person, you may not be liable for culpable homicide. And if you are not liable for culpable homicide, then there is no chance that you may be held liable for the concept of murder. And I rest my case. I hope it's clear now. If it is clear, quickly give me a thumbs up. I'll move to the next question. Now the last question. What offense that brother and F has committed? No offense or any offense which you can think of. Yes, please. Which offense has been committed by brother and F? Or your answer may be, your answer may fall under no offense as well. That is something which is completely upon you. So no offense or any offense. Gayatri, first one to answer, no offense. Okay, what about others? Shiv Gauri, Shivangi, Kumar Praful. No offense, Shiv Gauri. Okay. Okay. No offense. Okay. Come on, I can at least expect one correct answer. You are not thinking much. Just by reading all your comments now, I can assure you, you are not thinking much. No offense. Now please do contradict me. I am saying that brother and F has committed attempt to hurt. Am I wrong? Please feel free to write. Attempt to hurt. Attempt to hurt. And attempt to hurt is an offense or not? I guess so, yes, under section 511, because there is no specific section of attempt of hurt. Yes, please do contradict me. Yes or no? You are saying the answer is no offense. I am saying the answer is attempt to hurt. No, they just don't visited the house. They abused him as well. They have done assault as well. And they are running behind him only to beat that person, right? There was no sports going on. The intention to run behind Mr. X was very, very clear, that we are going to beat that person. And that is why, just because they don't have any sharp weapons or guns or, hatchet, so that's why I'm putting this into attempt to hurt. Yeah, assault they have done. So you may charge us with assault as well. If it is clear, quickly give me a thumbs up. I'll move to the next one. Yes, please. Waiting for your thumbs ups. So now let me tell you the name of this case as well. If you want to go into the detail and if you want to read this case, the name of the case is, students, Joginder Singh versus State of Punjab, 1979 Supreme Court. Yes, please. If it is clear, quickly give me a thumbs up. Then it is assault, criminal force, and attempt to hurt. Yes. Criminal force you can say, assault you can say, attempt to hurt you can say. But no offense is not the correct answer. Okay, let me make it more interesting for you. Let me make it more interesting for you. Wow. Let me raise one more question. How many of you think they will get right of private defense as per to those same facts? Right of private defense. Will they get benefit of right of private defense here or not? क्या बात है, बहुत बढ़िया. चलिए, let's revise the concept of Right of private defense here. Shiv Gauri, please do mention your reasons as well. If you are saying no, what are your reasons? Why you are saying no? Kamar, Kamar Bhatti, no. Okay. Uh, Bhatti, please do write your reasons as well. Why you are saying no? If you are saying that they will not get right of private defense, why no? Why not? Okay, Gayatri also no. What about others? I need some water. Yes, please. I am inventing the most interesting questions you can think of. Okay? And if you are still don't want to apply your judicial mind, God bless you. I have not received the reasoning. Why not? Geet Sharma, no. Okay, Geet. Reasons. Okay. Finally, I have got one reason. No, because this case does not fall in general exceptions and they themselves had assaulted X. So, no benefit of right of private defense. Shiv Gauri, my counter question to you. When you go from the list of section 100, you may fall this under, let me tell you, the exact wording of section 100. Okay, where is my Bayrat? Just a second. Gratifying lust. I think something like this. Okay, let me give you the exact wordings. Section 100, section 100. Section 100, fourthly, assault with intention of gratifying unnatural lust. Yes, please. And now Shiv Gauri has convinced. Yes. Bhatti, it is not a general exception. Bhatti, then what section 100 is? Section 100 fourthly. Will they get benefit of section 100 fourthly? Yes or no? Yes, see, there are only two ways. Either you will get convinced, yes sir, this will fall under section 100 fourthly, or you are going to say, no sir, this will not fall under section 100 fourthly. Now you tell me. Should I conclude? I guess I should answer now. Okay? Chaliye. Now let me answer. See, the correct answer of the question number 4 is they will not get benefit under any of the general exceptions. Either it is right of private defense or anyone else. Now the question is, then sir, why not section 100 fourthly? And your answer should be that sir, section 100 is always read with section 102, which basically tells you the commencement and continuance of the right of private defense. And here in this case, they did not have, as per to section 102, they did not have right to private defense. They have sufficient time to go to the police station, to go to the authorities and lodge their whatever the complaint, FIR or whatsoever. Fine. So this is why they will not get the benefit of any of the general exceptions, especially right of private defense. If it is clear, quickly give me a thumbs up. If not, if you still have any questions, if you still have some counter questions, what about this particular section, you may ask. If not, quickly give me a thumbs up. I'll move to the next one. Please feel free to ask, Bhupendra. Please, waiting for the questions. Chaliye. I'm happy that Bhatti, you are not clear with the concept. Yes, Bhupendra, waiting for your questions so that I can answer and move on to the next one. Sir, there was no case of gratifying unnatural lust. Um, I think it would be hard to search for, but passing this statement that there is no case law of on gratifying unnatural lust, because the answer to this question is subject to the research you put in. Okay? So there is no landmark judgment, I can assure that. There is no recent judgment, that I can also assure you. But yes, if there is any particular case or not, that you have to give sufficient amount of time on Manupatra, SSC Online, or any other or Google, right? Okay, Bhupendra, answer to your first question, offense and crime may difference. See, crime is a very general term. Let me give you this chart to understand this concept. This bigger circle is basically crime, and this inner circle is basically offense. When you say murder, so murder is an offense under section 300, which is punishable under section 302. So murder is an offense, right, under section 300, defined under section 300 and punished under section 302. But whether murder is crime or not, the answer is again yes. Crime is a more, you can say, a general term that has been used. But when it comes to IPC, the meaning of IPC is that IPC is nothing but it is law of crimes that states offenses and their punishment. तो आईपीसी में आपको सारे क्राइम्स ही मिलते हैं, बट क्राइम इज अ वेरी जनरल टर्म. तो पनिशमेंट किसके लिए मिलेगी? किसी स्पेसिफिक ऑफेंस के लिए. विच मीन्स इफ सपोज दिस मिस्टर ए हैज डन सम एक्ट, and now if that act is not an offense, mind it, if this act is not an offense under IPC, so whether this person will get the punishment under IPC or not, the answer is very simple, no. So if the person is getting punishment, he is getting punishment for offenses. Now these offenses are, the major criminal law, major substantive criminal law is IPC, where there is a list of offenses: offenses against body, offenses against property, offenses relating to marriages, offenses relating to elections, if offenses relating to coins, offenses relating to documents, that and so on, right? So these are the offenses, the specific terms. These all the offenses has been defined in IPC as well. But crime is a very, very general term. Okay, let me give you one more example on this. Blackmailing. Blackmailing is an offense under IPC or not? You please answer. Yes, blackmailing is an offense under IPC or not? Blackmailing is a crime. It's a crime. You cannot blackmail someone, anyone. In our movies, in our dramas, web series, this is a very common term, blackmailing. But when it comes to IPC, IPC has not defined any of these terms. What is blackmailing, right? And this is just an introduction I have told you. We can go into much details. What are the differences? The term crime has not been defined, but offense is under section 40. Okay, but I hope I've given you sufficient answer. Done. Bhupendra, 376.2 and 376C में difference. 376.2 and 376C. Just a second, I'm referring to the right. Okay, I have got what has been written under 2. Now coming to C. Bhupendra, I request you to please rephrase your question, because I have got section 376 clause 2. Okay, like it started from whoever, being a police officer, being a public servant, being a member of armed forces, and so on. The list has been given. But what is section 376C? So you have to mention the clause. Section 376, which clause? And so you have to rephrase it. There is no section 376C. So you are talking about section 376 clause 2 subclause C. Please confirm. If that is the case, I'll answer. Please confirm, Bhupendra. Okay. Okay. Now I'm answering your question. Listen carefully. See, students, when it comes to section 375, it talks about what is rape. Okay. What do we mean by this term rape? By the way, I can give you a good homework as well. You know, there is one concept which is in news these days. Anyone of you know what is digital rape? And trust me, if you have not read about this, you may not have any idea about this, because just because the term digital has been used, that has nothing to do with IT Act or computer or laptop or something like that. Let me tell you this as well. Okay, so I'm just giving you this as a homework. You should know about this. Just Google it, or you may watch any of the YouTube video and you will get to know about this. Done. And it's an important concept. Yeah, it's a Delhi case. I think it's a Gurgaon or Noida case as well. Okay, so digital rape. Okay, now coming to the next one. So what the question was about. Now when it comes to section 376, students, section 376 is basically punishment for rape. Okay, and when it comes to section 376 clause 2 specifically, it talks about if your case falls under this list. Now, in this whole list, I can mark you section 376 clause 2 subclause A, police officer; B, public servant; C, armed forces; D, management or staff of jail; E, management or staff of hospital; F, relative, guardian, teacher, or. There is one common factor in this list, if you can catch that. What is that common factor, students? That common factor is basically that the person, is an authority or known. Then, see, rape can be committed by anyone, but if this particular offense has been committed by someone who must prevent it, or someone who we cannot expect it from, if that person is committing it, then the punishment is going to be more. It is something like that if someone who is teaching law, who is learning the law, and that same person is not a law abiding citizen, so in that case the liability is higher in comparison to someone who is just illiterate, who has no idea what the law is. I know ignorance of law is no excuse. That person will also get the benefit. But if there are two accused, on one hand there is an expert in law, he knows the law, and on the another hand there is a person who has who's completely illiterate, who don't know anything. Now obviously the person who is literate will get more punishment. So similarly, the common factor in this clause 2 is that the authorities, the person, we cannot expect that from them that they are going to commit offense. For example, when you go with the clause C, member of armed forces, then if they are committing the rape in their area, that is usually considered as the most safest place. Then if one of you is from, if you are from if any of your parents is an army, you must relate to that the whole army area is considered as the most safest area in comparison to any other city or any other area that has nothing to do with that. So that is why the punishment is higher in this case. Done. And yes, one more thing, when it comes to this area, usually police officers don't interfere there, right? So that is also, all the guards, all the security you will get there is from army only. That. And let me give you one more example here. When you will read section 376 clause 2 subclause D, you will find being on the management or on the staff of jail, which means suppose there is a lady and she has been arrested and she is in the jail. So jail, the perception is that the jail must be, and should be also, the jail must be most safest place for anyone. And if someone is getting raped there by that person, whose duty is to, that something like this should not take place. So the liability is going to be more. So that is the major difference, right? चलिए जिन्होंने पढ़ लिया बहुत बढ़िया. Okay, Bhatti has also a question. 182 and 193 में difference. 182 and 193. 182 and 193. I think there is no similarity between 182 and 193. This is the first time I have got this kind of a question, but whatsoever it is, I'll answer. See, when it comes to section 182, this basically falls under related to public servant. I hope everyone do understand who is a public servant. Section 21, there is a complete list. So if you are a public servant, done, and you are the one who is doing any kind of contempt, done, so you will get punishment here. So 182 is basically false information with intent to cause public servant to use his lawful power to injury another person. Just a second, I'm thinking of an example here. Suppose there is a police officer and he is doing the investigation. Okay. And while his investigation, he asks some questions to Mr. X. And Mr. X intentionally gives false information to this police officer. Okay. So that, someone else get the punishment. So which means a person is giving false evidence to a police officer. That is a public servant. So the person will get the punishment as per to section 182. Now coming to 193. 193 is a general provision, which means if you are giving false evidence in the court of law or to any person, to the whole criminal justice system, if you are giving the false information, so that's a general provision, you will get punishment under section 193. I hope it's clear. Bhupendra, you are asking about rape and sexual intercourse mein difference. There is a lot of difference. Okay? There can be rape without sexual intercourse. Okay? Rape is an offense. Sexual intercourse is never an offense under any of the sections. So there is no similarity between these two topics. Done? Okay, I guess I have answered everyone. If yes, quickly give me a thumbs up. Okay, it's time as well. Chaliye, if it is clear, then I'll wrap up the session. I'll continue with these cases in the next class. So students, this is the link of my profile on Unacademy. So make sure you follow that to get all the updates about my special classes and my plus courses. This is the link of my Telegram channel where you can connect with me. And this is my code Khatri10, which you can use to get free access of all the special classes available on Unacademy app. Let's crack PCS J with Unacademy. Students, there is an important information for you that there is an offer going on from October 18th to 21 where you will get a 1 month subscription free with 6 months subscription, 2 months subscription free with 12 months subscription, and 4 months subscription free with 18 months subscription. Okay, so that is the offer which is going on. These are the recently batches which has been which is going to be start from October 20. There is a judiciary test series going on for October. There is judiciary mains test series going on. There is a test series going on specifically on case laws, on judgment writing. This is the result from Unacademy in Rajasthan Judicial Services examination. This is the batch which has been recently started. This is the batch which has been again recently started from September 29. There are free special classes available every day on Unacademy app. These are some special class features. These are some Unacademy iconic features. This is the pricing plan and the plus subscription. This is the pricing plan and the iconic subscription. This is the YouTube and the Telegram channel of Unacademy. And that's it from my end. See you in my next class. Till then, yes, it's time to say peace.